My name is Bart Wasiak. I'm a senior associate with Arnold and Porter in London. And it's my pleasure to moderate this panel discussion on the growing importance of the role of international economic law in a globalized world. Now, I haven't had a chance to discuss this with the conference organizers, but it always struck me that the topic of our panel is somewhat perhaps provocative. There is something provocative about, stating that the role of international economic law is of growing importance in a world where that law and indeed international law in general is facing many challenges. As you know, in recent months and years, we have seen multiple examples of these challenges. We've seen, for example, the WTO dispute settlement mechanism being effectively paralyzed by the US vetoing the appointment of judges to the appellate body. We've seen multiple states withdraw or openly refuse to comply with awards issued in, withdraw from treaties or refuse to comply with awards issued in investment treaty cases. The IMF and indeed the world is struggling to come to terms with the US administration's imposition of, quite extraordinary tariffs. And indeed, more broadly, I think we were seeing a lot of challenges to this, liberal, rule-based economic and international order. So these are challenging times, but as I said, despite these challenges, or maybe precisely because of these challenges, international law and international economic law in particular have I think, an important role to play. And that is precisely the role of our panel discussion today. We're very lucky to have hopefully four, three in person and a fourth speaker, hopefully joining us remotely, four prominent speakers who, and I think this is particularly interesting, they will each address this overarching topic from a different, somewhat different perspectives, but in all cases, very interesting and very timely perspectives, I think. I will introduce each of them briefly, perhaps before they speak, but by way of preview, we have with us Dr. Ernst-Ulrich Petersman. We have Dr. Konstantina Georgaki. As I mentioned, we don't have with us in person. Hopefully we'll have remotely Dr. Abdulkadir Nacar. And we have with us here in person Ms. Khrystyna Kostiushko. Just briefly in terms of logistics, each of the speakers will give a 15-minute presentation. And I apologize if I have to try to limit those presentations to 15 minutes due to time constraints. I would ask that you keep any questions till the end. I'm hoping that there will be questions for each of our speakers. If not, I will likely have some. And with that, let me just briefly introduce our first speaker, Dr. Ernst-Ulrich Petersman. He's a professor emeritus at the European University Institute in Florence, Italy. He previously taught constitutional law at the Universities of Hamburg and Heidelberg, and he was professor of international law and European law at several universities and institutions. He taught international economic law at the Hague Academy of International Law, and again at multiple universities in Europe, Asia, Africa, and the Americas. So that's, I think, basically everywhere, almost. And he's published more than 35 books and hundreds of contributions on topics of international law, European law, and comparative constitutional law. There's many other accomplishments that I'll omit just for reasons of time, but I invite you to review his CV. And Professor Petersman, the floor is yours.
The title of my presentation is Constitutional Pluralism as Political Driver for Multipolar Reordering of International Legal Systems. And the research question of my presentation is exactly the same as the question raised by Professor Engi. in his keynote lecture. That is, how should responsible governments respond to the intergovernmental power politics, which is currently destroying the UN legal system, like the Russian war against Ukraine, and the American trade wars destroying more or less the WTO world trading system. And also the final conclusion of my presentation will be very similar to what Professor Engi said at the end. We have to transform this neoliberal power politics into a social market economy respecting social solidarity. That's what we have done in European integration law with the social market economy, which we created in Europe as a response to the First World War, the Second World War, and to dictatorships and Holocaust. And here, my methodology is based on systems theory and constitutional theory. So systems theory says that international legal systems like the UN or WTO are very dynamically evolving through interactions between the rules, the institutions, and the governance practices. And here, constitutional theory complements systems theories by trying to explain why is it that now certain UN member states engage in military wars like the Russian war against Ukraine, completely inconsistent with the basic UN fundamental rights and rule of law principles. Why is it that the Trump administration now destroys the multilateral trading system through a governance method by 140 presidential orders, which is undermining the universally agreed sustainable development goals? And here I ask three questions from a constitutional perspective, and I propose 8 legal hypotheses from a constitutional perspective in order to better understand the chaos which is currently happening in the United Nations and the WTO legal system. And let me add, I have worked more than 45 years as legal advisor in the WTO, in GATT, in the United Nations, and representing Germany in European institutions. So I'm more a legal practitioner and not only an academic professor. And here I will try to use the remaining 13 minutes or 13 minutes for just presenting these 8 legal hypotheses in order to help all of us to better understand the chaos which has happened over the past year or month, and which is likely to continue for the rest of the presidency of Mr. Trump, at least. So the first legal hypothesis is that international relations are not only driven by power politics and by nationalism, but they are increasingly driven by constitutionalism. And I use the term constitutionalism very broadly. That is, all UN member states use constitutionalism for constituting, limiting, regulating, and justifying governance powers. But they do it in very different ways. And we have authoritarian systems, we have democratic constitutional nationalism, and we have multi-level constitutional systems like in the European Union or in the European Economic Area. And these diverse constitutional systems, I would argue, can explain why we have these dictatorships starting military wars against Ukraine, for example, or why China is starting military action against other WTO members like the Philippines and Taiwan, and why we don't see that inside the European common market or inside the European other European organizations due to rather effective constitutional restraints which have protected international rule of law in Europe and have prevented wars in Europe rather effectively. Now, second hypothesis is that authoritarian constitutionalism is fundamentally different from democratic constitutionalism or from multi-level European constitutionalism. So authoritarian constitutionalism, for example, in Russia, in China, in North Korea, or in Iran, focuses on power monopolies, not a rule of law, but rule by law. It suppresses human and democratic rights not only inside the country, but also in the external relations. And so we see increasingly military aggression against Ukraine or against Philippines or other countries. So, and they use state capitalism as an instrument of using the economy for the benefit of the power monopolies, essentially, but also, I mean, we have to distinguish here, I think, very much between the Chinese way and the Russian way. Second, democratic constitutional nationalism provides for effective constitutional restraints on domestic governance powers, but not on foreign policy powers. Here, the prevailing paradigm remains foreign policy discretion. And we have seen that includes Brexit, the withdrawal from the European Union, or it includes now the trade wars initiated by President Trump, who is invoking a very strange theory interpreting the American Constitution like Hitler. Was Carl Schmitt, the lawyer of the legal advisor supporting the Hitler Nazi government, was interpreting the Weimar Constitution. That is, they justify extremely broad interpretations of emergency powers by the executive, undermining the legislative and judicial functions in a democracy. And here, I think you see completely different market economies, rule of law, not only rule by law. You see effective constitutional constraints inside these democratic countries, but the foreign policy discretion is much broader than what you see in multi-level constitutional orders like the European Union or like the EFTA countries. And here, I think the European experience is based on the fundamental failures of the First World War, the Second World War, the Holocaust, the dictatorship in Germany. And we have accepted that we need multi-level constitutional restraints on market failures. There are 5 different kinds of market failures, which are regulated in European law by competition law, environmental law, social law, internet regulation, and protection of public goods, but which are largely ignored in American neoliberalism or not effectively dealt with. So, this multi-level constitutionalism, which you see in Europe, is also based on European court systems, European parliamentary systems, European regulatory institutions, which limit intergovernmental power politics much more effectively and which have prevented wars over the past 75 years among the 27 EU member states, the 4 EFTA states, and the other European states which have, like Switzerland or Turkey, which participate in the European common market in different modes. My legal hypothesis 3, 4, 5, 6 focus on the very different international legal policy competition among authoritarian states. And here, I mean, up to the 1990s, there was a lot of power rivalry between, as you know, between the Soviet Union and China. But since the 1990s, they cooperate increasingly. But here, I mean, the regulatory competition is essentially based on power politics. So if you look at the external agreements concluded by China in the Belt and Road context, the bilateral trade agreements do not provide for human rights protection or for independent judicial remedies. They are fundamentally different from what we see in trade and investment agreements of democracies. And the basic idea, I mean, of regulatory competition among democracies is this idea of liberal cooperation, which is mutually beneficial and which must protect public goods, international rule of law, for example. But of course, the UN and the WTO were essentially negotiated by democracies for democracies, and they had certainly imperial elements as described by Professor Angie. But we see here increasingly intergovernmental power politics also undermining the UN and WTO legal systems due to this very vast foreign policy discretion. Nobody in the United States holds Mr. Trump accountable for destroying the WTO legal system, for destroying the WTO dispute settlement system, for creating economic chaos, disregarding the 17 universally agreed sustainable development goals. Now, the competition among states, democracies which participate in multi-level constitutionalism is again completely different. So we have EU member states, 27, we have EFTA member states, 4 EFTA member states outside the European Union. We have countries like Mexico, like Switzerland or Turkey, which participate in the common market, but say, no, we don't want to join the European Union. We don't want to join, Switzerland doesn't want to join the European Economic Area. Or like Turkey, they don't meet the membership conditions. So there is a lot of diversity in regulatory competition, which is quite different. But the overall dynamic of these different forms of regulatory competition, unfortunately, changes not only the primary rules of conduct of the UN system and the WTO legal system, but also the secondary rules of recognition, change, and adjudication. That is, they change the constitutional foundations, the challenge, the constitutional foundations, I think, of the UN system and of the WTO system. And the outcome, I think, remains open, but I think it is the responsibility of the majority of the less developed countries and of the European countries which are committed. The Lisbon Treaty requires in Article 3 of the treaty strict compliance with international law. And so here we have seen yesterday that the less developed countries take increasingly countermeasures by invoking the International Court of Justice and the International Tribunal of the Law of the Sea. My hypothesis 7 just lists 6 countermeasures by the European community in order to defend the UN system and the WTO system. First example, the multilateral WTO interim arbitration based on Article 25 DSU. Second example, carbon border adjustment measures aimed at increasing the carbon mitigation reduction commitments by all states, that is going beyond the Paris Agreement on climate mitigation, which is obviously not sufficient. Third example is the EU response to the COVID pandemic, which was creating a fund of 800 billion euros and distributing this fund especially to countries, European countries, which were most affected by the health pandemic. I don't have the time to go into the other examples, but I think, I just use the example of European countermeasures, but we discussed yesterday and today also the countermeasures by less developed countries. So my final legal hypothesis is here this regulatory competition among authoritarian countries without effective constitutional restraints, democracies with limited constitutional restraints on foreign policy, and multi-level constitutionalism practiced essentially in Europe, and the countermeasures requested by developing countries, requested by European countries, create very dynamic interactions trying to limit this intergovernmental disruption of the UN system, of the WTO system, trying to reform the climate change regime, for example, and to protect the universally agreed sustainable development goals. The future is not clear, but I think when we see the negotiations between President Putin and President Trump, they are challenging Hughes Kogan's prohibitions of recognizing illegal annexation of foreign territories. This is the Hughes Kogan's foundation of the existing international legal system. And if we look at the countermeasures, I think it is completely justifiable that Western democracies have frozen about 200 billion of Russian central bank assets. And the basic idea is to transfer these central bank assets to a compensation fund, which should help Ukraine to force Russia to comply with its international legal obligations of repairing the injury in Ukraine. But I mean, these countermeasures remain very contested, and the future depends, I think, on the less developed countries and the European countries to defend the existing UN and WTO legal systems, without which we can forget about the Sustainable Development Goals. And I think that was the last question by Professor Engi. We have to reinvent a common humanity which effectively protects the 17 Sustainable Development Goals, and that can be based only on a kind of social market economy, not on American neoliberalism, and by respecting the need for social security, social solidarity, and that's a big challenge, and nobody of us, I think, knows the answers, but we have to work for that. Thank you very much.
Thank you very much, Professor Petersman. Our next speaker is Dr. Konstantina Georgaki, who's an assistant professor in international and European economic law at the Aristotle University of Thessaloniki. She holds a doctorate in law and a master's in legal research from the University of Oxford, an LLM in commercial law from the University of Cambridge, and if that were not enough, also an LLB and LLM in public law and an LLM in civil law from the University of Athens. Dr. Georgaki previously lectured on EU law and constitutional law at Mansfield College, Oxford, and worked as a policy officer at the European Commission, focusing, among other things, on the negotiation of international trade and investment agreements at the EU level. She's published widely on various questions of public law, EU law, and international law, including on investment protection under the EU and the international legal frameworks. And she will present to us today on the topic of the EU's defense to economic warfare, the long-awaited U-turn. The floor is yours.
Well, good morning from my side as well, and thank you, Bart, for a very thorough presentation of what I've done and who I am. So, as our moderator kindly informed you, I'm Dr. Konstantina Georgaki. I'm an assistant professor in international and European economic law at Aristotle University of Thessaloniki. And I think to a certain extent, this also explains the topic on which I will be presenting today, which is the EU's defense to economic warfare and whether this has been a long-awaited U-turn. Halfway through my presentation, or at least the preparation of my presentation, I realized that this is a topic that on which I could go on forever. So I will start with a brief introduction on the so-called European Union economic defense instruments, which have been adopted starting the first Trump administration. In fact, this is what prompted the adoption of the first instruments to find ourselves in the second term, needing them very urgently. And then I will focus on the implementation of one of those instruments, which is the so-called anti-coercion instrument, a regulation that was, it's actually the most recently adopted economic defense instrument. It was only adopted at the end of 2023 to enter into force in 2024. And whether this is an instrument that could, in fact, operate as a form of defense to the newly second round launched economic wars by President Trump. Starting out with a brief presentation of the EU's market. So the EU is a very open trade and investment regime, and this is an openness that is enshrined, for better or worse, in its constitutive instruments in the EU treaties. The EU has a number of powers with respect to external action, hence its power to negotiate and conclude international agreements, and also to become itself part contracting party and a member of international organizations, as is, for example, and most notably, the World Trade Organization. So with respect to that, the EU has very early on in its development realized the benefits that an open trade and investment regime can bring into the EU's economy. Bringing in capital, bringing in critical technologies, boosting development through the creation of jobs, creation of new markets for its exports, the cheaper imports, which can in fact be to the benefit of consumers and so on and so forth. So the EU currently is, together with its member states, but with respect to the division of competences, only the EU can in fact participate and decide on relevant questions. The EU is a party to the WTO, and it also has in place 44 preferential trade agreements with third countries. At the same time, when it comes to the EU's internal market freedoms, the freedom of establishment and the free movement of capital can be very relevant, both for traders as well as for investors coming from third countries. It's a common secret within the internal market that there's a sort of regulatory race to the bottom with respect to that. So it's possible for third country traders to establish a company anywhere that's easier to do within the internal market and then benefit from the freedom of establishment and a free market in the whole of the EU. At the same time, when it comes to investment, there's a free movement of capital, which is the single fundamental freedom that is open not just for EU undertakings, but also for third country undertakings directly on the basis of the EU treaties. And this is a freedom which opens up the market to investments, at least in principle, from third countries. Investments from third countries, both foreign direct investments as well as portfolio investments, can in fact penetrate the EU's market on the basis of its very fundamental freedoms, making the EU's market a bit more susceptible to economic warfare and the weaponization of investments, and also trade through the freedom of establishment. This has been quite obvious starting the first Trump administration in 2016, when we have a number of first instruments coming into play as the EU gradually on its own, and also prompted by the member states, start to complain on a number of occasions, especially when it comes to the third country investors, most notably, obtaining control or ownership of undertakings in strategic sectors for the EU's economy, critical infrastructure, pharmaceutical, critical technologies, and so on and so forth. So there's a number of member states in the EU realizing that there needs to be something done in order to try to, if not limit, at least obtain control as to how one can penetrate the EU's market. Again, this is an issue, this is a defect of sorts, but I'm very reluctant to call it a defect, of the EU's constitutive instrument. So this is not something that can be abolished by the EU. That requires an amendment of the EU treaties. But this is something which the EU, again prompted by the international situation, the first economic war launched by President Trump, and a number of other challenges, including but not limited to the Russian war of aggression in Ukraine, the COVID-19 crisis, the war in Gaza, and so on and so forth. So the EU started, as of 2016 onwards, to adopt a number of instruments of secondary EU legislation in the form of regulations in order to obtain uniformity within, when it comes to their application, in order to protect its market and try to shield it from unwanted trade and investment weaponization. These instruments, and now we're talking about 6 regulations that have been adopted in between 2016 and 2023, the last one being the anti-coercion instrument. These are what I collectively call, for our purposes here, the EU's economic defense instruments. This is an important policy change, and now we see that it's also reflected in the current Commission's political priorities for its current mandate. What is interesting is that the prioritization of trade and investment has always been a priority for the European Commission. The difference now being is that the priority is no longer the openness of the EU's regime to trade and investment coming from third countries, but rather the possibility to defend the market from this kind of weaponization. So trade and investment still a priority, but from the other side of the spectre at the moment. I mentioned that there are 6 regulations. The first 2 were adopted in 2016, and it was in the light of what seemed to be going on in the WTO already at the time, which are the anti-dumping and the anti-subsidies regulation, trying to implement different obligations and provide some specialization with respect to the measures which the EU could adopt in order to deal with dumping practices, unfair trade practices, dumping and subsidies. Then to be followed by a number of regulations that are mostly targeting investment weaponization, the FDI screening, the foreign direct investment screening regulation that allows or provides certain criteria for member states to respect when they put in place such screening mechanism for foreign direct investments on grounds of security or public order. There's also the international procurement instrument, which basically allows the EU to close its public procurement market to third country operators and country goods or services in case on reciprocity grounds, most notably, because since the EU has a very open market when it comes to trade and investment, this openness is almost never reciprocated by its third country counterparts. A recent regulation is also the foreign subsidies regulation, which is essentially the counterpart of state aid, which operates internally within the EU and within the member states. And now it's basically capturing subsidies also with respect to services and investment, which basically may penetrate the EU's market. And the last instrument, which is the more important one for the purposes of this presentation, is the anti-coercion instrument, Regulation 2675 of 2023. The anti-coercion instrument is basically a regulation which aims at providing the EU with certain tools that it can use in case there are practices which qualify as economic coercion coming from third countries in order to interfere in its legitimate sovereign choices. And this is how the recently launched second economic war with the US comes into play. So as of when his second term started, and also culminating recently in the beginning of this month, we have President Trump implementing again a number of tariff measures, increasing number of tariffs, targeting different countries, both specifically and also in a cross-cutting manner. So we see that there's a tariff increase when it comes to Chinese goods of 145%. There's measures targeting Canada and Mexico, which have now, for the most part, been withdrawn. And there's also a cross-cutting increase of 10% on all goods coming from all other countries, and a 20% tariff, which has now been frozen, suspended at least for 3 months, targeting the EU specifically, and also a number of different tariffs targeting specific types of goods. So steel, aluminium, automobiles, and at the end of this month, also spare parts of automobiles. The EU is mostly now considering how it's going to react. It has already adopted a number of countermeasures because the EU, as of the first trade war, considers these measures to be illegal safeguard measures in the context of the WTO. So already then and now, the EU has adopted a number of countermeasures targeting equally goods coming from the US. The EU is currently also considering other ways of reacting to this practice, which seems to be a practice that is here to stay. One of the instruments that the EU is currently considering implementing is this specific anti-coercion instrument. And in order for it to, for this practice to be a practice that can qualify under the anti-coercion instrument, there are a number of both substantive conditions as well as procedural conditions that need to be met. When it comes to the substantive provisions, the substantive conditions, in fact, the most important element is for the imposition of tariffs to qualify as economic coercion. And economic coercion is authentically interpreted for the purposes of the regulation as any measure which affects or threatens to affect trade and investment, and basically it is meant to prevent or cause for the cessation, the modification, or for the adoption of certain acts, of certain policy acts by the EU or the member states, thus interfering in legitimate sovereign choices of either the EU or the member states. Essentially, it's any practice which is adopted in order to push the EU or the member states to either do something or basically stop doing something. And that's the most important element. There's also procedural conditions that need to be met, which are basically a four-stage process. So we start with determination, which is the Commission trying to obtain information from all available sources to see whether what this practice does, what the intent behind this practice is, how much interference in sovereign legitimate choices we're talking about, and so on and so forth. The second term is basically, the second step is basically a proposal to the Council in case the Commission is satisfied that there is a practice that can qualify as economic coercion, and for the Council to adopt a decision acknowledging that there's in fact economic coercion, a practice which fortunately for us does not require unanimity but rather qualified majority, so 55% of the member states representing 65% of the EU's population. The third step, once the Commission has proposed the adoption of this Council decision and the Council has adopted its decision, is engagement. So the EU has to, in fact, engage with the third country, which is putting together economic coercion against the EU or any of its member states, and try through negotiation to obtain the cessation of this economically coercive practices. And the fourth step is response measures. So should conciliation of sorts not be successful, then the EU can adopt, the Commission, through an implementing decision, can also adopt response measures against the third countries. Response measures are an interesting animal here because they can be either of general application, so basically countermeasures, measures targeting trade and services, measures targeting investments, but also, interestingly, they can also target specific natural or legal persons that are connected or linked to the government. And here, it would be interesting because not only could you target trades in goods, services, or investments coming from the third country at hand, but also specific individuals that are somehow linked or connected to the government. For example, Starlink or Tesla or Elon Musk himself or Donald Trump, for that matter. Whether, of course, a practice qualifies as economic coercion, that is something for the Court of Justice to finally decide if all those acts are in fact challenged before the Court of Justice. Whether these practices would equally be compatible with the WTO framework, which is a condition necessary not only for legality with respect to the international framework, but also legality with respect to the EU legal framework, because the regulation also mentions and imposes an obligation for these measures to be compatible with the EU's international obligations, hence including WTO. That's a question for the WTO dispute settlement body. Unfortunately, as the situation is now, that is no longer an option. The last thing I would like to mention, and then I will conclude this presentation, is basically has to do with EU politics, essentially. So the reason seems that the EU is currently considering implementing measures and basically launching an investigation under the anti-coercion instrument at the moment seems to be that it considers this anti-coercion instrument a last resort. And it considers this anti-coercion instrument a last resort because unless the EU and the Commission is satisfied that the member states are actually going to adopt its proposal to move forward and adopt an implementing act, this is going to look to its counterparts in the third country, in fact, implementing economically coercive measures as a failure. So unless they're satisfied that this is a decision that is actually going to be adopted, even with qualified majority, and that they have the numbers in the Council, they're not prepared to move forward with it because they consider this to be the last, their last resort. That's it from me for now, and I look forward to your questions. Thank you.
Thank you very much, Dr. Georgaki. And now, hopefully, our next speaker is going to be Dr. Abdulkadir Nacar, who's a researcher at the Istanbul University. He holds a bachelor degree and an LLM from the Marmara University and a PhD from the Istanbul University. He's written on such topics as crimes against humanity and environmental soft law. And today he will present on the topic of decentralized finance as a tool for objective global sanctions, integrating capital influence within the UN system. Dr. Nacar, I hope you can hear us and maybe see us. We're sorry that you're not here, but we look forward to your presentation.
Hello, my name is Kadir Nacar. My main areas of studies are environmental law and international economic law. The topic I will present today is somewhat broad, but I will do my best to summarize its core elements efficiently. The title of my presentation is Decentralized Finance as a Tool for Objective Global Sanctions, Integrating Capital Influence Within the UN System. Due to unforeseen circumstances, I will be presenting online. My research focuses on the question, how can decentralized finance technology support a globally objective system to enforce international law, especially in relation to economic sanctions? This is important because current sanctions usually suffer from political bias. Issues like state capitalism, trade tariffs, and selective enforcement weaken their legitimacy. What we lack is a rule-based global system where sanctions are applied consistently and transparently. But there are challenges. The ambiguity of DeFi regulations, along with questions about state sovereignty and the enforcement of international law, must be addressed. So my research explores whether we can combine legal norms with decentralized infrastructure to move toward a global, credible, and rule-based enforcement system, not replacing states, but enhancing accountability through technology. I want to briefly introduce the nature of decentralized finance, or DeFi. At its core, DeFi is redefining traditional finance by replacing the centralized intermediaries with decentralized technologies. Through smart contracts and blockchain-based protocols, DeFi offers financial autonomy by enabling direct peer-to-peer interactions without reliance on banks or governments. One of its most transformative aspects is governance through decentralized autonomous organizations, which empower community to make collective decisions rather than deferring to centralized authorities. Crucially, DeFi eliminates state interference, reducing the ability of any single nation or institution to dominate the financial ecosystem. This structural neutrality enhances fairness and transparency. It also ensures resilience by preventing monopolization, a key weakness in traditional finance. As we move forward, understanding DeFi's potential role in global governance and regulatory compliance is essential, especially in shaping objective enforcement mechanism in international law, which is central to my broader research question. Now I want to discuss how a DeFi protocol could be situated under the UN Economic and Social Council. Unlike the Security Council, which often faces paralysis due to political deadlock, ECOSOC offers a more neutral and inclusive platform. It focuses on economic and social issues, aligning well with the transformative potential of decentralized finance. ECOSOC's structure enables multi-stakeholder participation, supporting innovation and development while remaining open to both states and non-state actors. This makes it a fitting institutional home for global DeFi governance. Key elements include Pacte Social, a form of equitable stakeholder representation, and a mechanism for oracular intervention, allowing ECOSOC to interface with the DeFi system when necessary. Finally, the EU's MiCA regulation offers us concrete legal framework that could guide the integration of security and compliance principles into this protocol, paving the way for DeFi's constructive role in international governance. In the first phase, envision to begin with the implementation of ECOSOC protocol, the focus is on enforcing international and national court decisions through DeFi infrastructure. The aim is to establish an autonomous mechanism capable of executing decisions from institutions such as the ICJ, ICC, and even Interpol-related actions. For national court decisions, enforcement would require compliance with standards set by instruments like the Hague Judgment Convention or the New York Convention. How could this mechanism function? The verification body within ECOSOC would be tasked with the authenticating decision before they trigger binding smart contracts. It enables phased enforcement measures such as targeted set phrases, offering a scalable and legally robust solution. Crucially, the ECOSOC protocol would not issue legality certificates to all DeFi platforms. Instead, it would function as an oracle, supplying illegality feedback in alignment with DeFi's decentralized logic. By integrating DeFi's transparency with legal legitimacy, this approach seeks to establish a more accountable rule-based system, one that operates globally and autonomously, independent of traditional state enforcement. In the second phase, the ECOSOC committee assumes responsibility for implementing economic sanctions under UN Charter Article 41. This marks a shift from state-driven enforcement to a more decentralized, rule-based global approach using DeFi platforms. The aim is to depoliticize sanctions, removing arbitrary or unilateral actions, and replace them with technologically integrated mechanisms based on transparent, programmable criteria. Broader stakeholder involvement ensures legitimacy, including inputs from civil society, private sectors, and multi-stakeholder institutions. Through smart contracts, sanctions can be precisely targeted, affecting only the responsible entities while minimizing harm to civilians. This mitigates state-centric bias as enforcement decisions are made through multilateral consensus rather than great power politics. Ultimately, this phase focuses on both global security and sustainable economy. By embedding sanctions within a DeFi infrastructure, we introduce automation, auditability, and neutrality, paving the way for a fairer and more effective global sanctions regime. In this last phase, we draw from the theory of economic determinism, the idea that economic structures ultimately shape political and legal systems. As we transition into a blockchain-based financial architecture, this transformation does not stop at markets. It spills over into the political domain, gradually dissolving the traditional state-centric governance model. Once the DeFi-based system evolves into a comprehensive global compliance mechanism, it can autonomously facilitate rulemaking and dispute resolution. This means international governance become less about political negotiation and more about automated, transparent enforcement rooted in economic logic. To replace asymmetric decision-making, where dominant economies like the US or China dictate global rules, we propose a specialized, decentralized mechanism within ECOSOC, the Global Competitiveness Mechanism, the GCM. Compared to the WTO's slow state-based system, the GCM is faster, inclusive, and digitally native. It allows a real-time compliance, full transparency via blockchain, and smart contract-based enforcement. The shifts represent not just a technical innovation, but a redefinition of sovereignty, where legitimacy is derived from participation, transparency, and performance rather than territorial control. It marks the emergence of digital international law, driven not by states, but by interoperable economic protocols. These case studies illustrate how the DeFi-based global compliance model can address critical failures in the current international and economic order. First, in the Ukraine-Russia conflict, the ICJ's ruling to suspend Russian military operations was undermined by the UN Security Council paralyzes due to Russia's veto power. The DeFi model's first phase would allow the automatic enforcement of such rulings. A decentralized mechanism under ECOSOC could freeze digital assets linked to military operations, disrupting illicit funding channels in real time. Second, the US-China trade war highlights how state-driven tariffs and restrictions create uncertainty and protectionism. In the DeFi system, these measures become economically unsustainable. As peer-to-peer platforms gain prominence and dominance, the ability of the states to enforce restrictive policies diminishes. In the third phase, through the GCM, adherence to transparent and fair competition standards becomes more economically advantageous than resisting them, shifting the logic of compliance from coercion to incentive. This model creates a more resilient and rule-based global order. Finally, there are two major practical concerns of implementing DeFi-based international legal systems: resistance from states and cybersecurity vulnerabilities. Drawing from Zygmunt Bauman's critique of global capitalism, the decline in state sovereignty becomes evident as transnational corporations such as BlackRock, Vanguard, and State Street amass more economic power than many nation states. Their dominance, particularly as the big three with major holding in 88% of S&P 500 companies, challenges traditional political authority. Big Three's ownership of the system in ECOSOC could marginalize state resistance. On the cybersecurity front, while DeFi introduces risk, it also represents solutions. Like blockchain-based system can offer superior resilience through quantum resistance tools like QRL and IOTA, along with cryptographic techniques such as hash-based signatures. These innovations form a defensive infrastructure against digital threats, allowing DeFi governance models to operate securely and independently. However, ensuring trust and interoperability across jurisdictional domains a continuing limitation. Feel free to reach out with any questions. Thank you for your attention.
Thank you very much for that. We proceed. Okay, great. Thank you. This brings us to our last, but certainly not least, speaker, Ms. Khrystyna Kostiushko, who's an independent counsel and of counsel at the law firm Morris. She practices as counsel and co-counsel on international arbitration cases and teaches arbitration at the Paris Bar School. She previously practiced as counsel at a number of law firms, including at Berlin Pratt in Paris, where she gained extensive experience in investor-state arbitration. She's also served as tribunal secretary in commercial arbitration cases. She's admitted to the Paris Bar, the Kiev Bar, and is qualified in England and Wales as solicitor. And the topic of her presentation today is consequences of incorporation, annexation of the territory of territory for the spatial scope of application of investment treaties.
Good afternoon, esteemed colleagues. It's a privilege to speak for you today, and I'd like to extend my sincere thanks to the organizers of this conference and for the invitation and for bringing us all together to discuss this important topics. And my presentation today explores also very timely and increasingly significant issue for lawyers, but also for researchers and in investment law and its consequences of incorporation and annexation of territory for the spatial scope of application of investment treaties. And it's also linked to the topic that was raised by previous speakers, which is a Russian war in Ukraine, but not, yeah. And so when a territory is transferred from one state to another, maybe there are different legal issues, and some of them are quite complex that arise and in international law and specifically in international investment arbitration. And I think that this topic is not only of theoretical importance, but also of significant practical application, and specifically for those who are engaged in as lawyers in investor-state arbitration cases. And notably, those issues have already arisen and were discussed extensively. So these issues have already arisen in the practical sphere and in the wake of the Crimea annexation by Russia in 2014, and more recently in the context of Russian war in Ukraine, full-scale Russian war in Ukraine that started in 2022. And today I will focus on 4 key research questions that I looked into, and those questions are on the screen. And I will start with the general principles of state succession to treaties and investment treaties, so-called normal scenario, and then I will go into the discussion about the application of investment treaties in the territories which were illegally transferred from one state to another, and specifically the scenario of annexation. And I want to specify that this scenario is right now it's relevant for Ukraine and Russia, but in general, it's my analysis. It's applicable in general to any country and any investment treaty. So let me begin with the first question, and the question is whether the successor state automatically steps into the shoes of the predecessor state when it comes to investment treaties. So the short answer is yes. In normal circumstances, when there is no, let's say, war, and there is a peaceful transfer of territory, we call it lawful transfer of territory. The default rule comes from Article 14 of Vienna Convention on Succession of States in respect of the treaties, and sometimes this rule is referred to as a moving frontier principle. And normally the treaties of the predecessor state shall no longer apply to the transfer territory, and instead the treaties of the successor states begin to apply. So this is a normal rule, and this principle does not apply when a treaty is acquired illegally, such as through annexation. And why that? It's because of the also another well-known principle of international law, which is referred to as a non-recognition principle, or the principle according to which illegal acquisitions of territory are not recognized by the states and by the global community. And in light of this principle of non-recognition, the general regime of succession of two treaties that I've just discussed, including Article 15 of the Vienna Convention, wouldn't apply to in the scenario of annexation. And including the moving treaty frontier principle, it wouldn't apply. And then this rule is specifically reflected in Article 6 of the Vienna Convention, which says that the convention applies only in respect of the succession of states occurring in conformity with international law. And so this raises a serious concern for investors who invested in certain territory. What would happen to their rights, and who should be the state responsible for the breach, and who should be liable for the breach of their the obligations under the investment treaties, and under which treaty, most importantly, this questions should be considered, right? And what happens to the rights of the investors? So, and it's not an obvious question, not an obvious. There is no obvious answer to this question, and in order to analyze this question, I had to go beyond standard rules and ask, can international law preserve legal certainty for investors without undermining this principle of non-recognition? And specifically, you can see on the screen, so I started my research with discussing the question of the meaning of territory in public international law, and then I switched to meaning of territory in investment treaties in order to see if there is difference, or if there is any specific or different meaning that should be attributed to the term in investment treaties. And also, I was analyzing the question of the jure sovereignty and de facto control, and how do they influence the definition of territory, both in public and international law and in investment treaties. Because it may appear that the term territory is straightforward, but in fact it's far from settled. For example, in general international law and investment treaty practice, the meaning of territory is often open to interpretations. And if you look on this slide, you'll see that if we take general approach, there is most of the scholars, they would interpret the term territory narrowly, and narrowly meaning that it would include the land over which the state has a legal title or the exercises sovereignty. And there is also there are also some scholars that suggest that territory shouldn't be construed only. Territory shouldn't be equated to sovereignty, and it should be construed more expansively, especially in the context of investment treaty arbitration. So it would include rather the state's de facto control over a certain part of the globe. And as we know, sovereignty and de facto control is not the same thing. In the, if we look at the examples of Ukraine, right, where the territory can be considered sovereign territory of Ukraine, but it's under de facto control of the other state. So once I looked into the general public law approach on the definition of territory, I also analyzed the question of specifically the investment arbitration tribunals and investment law approach to this question, to see if there is some specific or something that would distinguish investment law approach from the general public international law approach. And in my research, I identified two broad categories of investment treaties. There are many treaties that would refer to territory very broadly as territory of a state, without any qualifiers, without mentioning sovereignty, without mentioning international law, just territory of a state. And one of this example is the Russian-Ukrainian BAT, bilateral investment treaty, where it says the territory shall denote the territory. And yeah, in the end, it mentioned the conformity with the international law, but the definition is it's rather goes into the definition of exclusive economic zone and continental shelf. But so in my opinion, and also in the opinion of some investment tribunals who already rendered awards on interpreting this provision of the BAT, this clause would be considered as an example of the broader the broad approach to the definition of territory, because it would include territory that is under de facto control of the state. But also in my research, I identified that there are certain treaties that specifically refer to the territory under sovereignty of state, and then unfortunately we don't have the practical examples of how would the investment tribunal decide in the case. Like if for example, here we had instead of territory, we had territory shall denote the sovereign territory of Russian Federation or sovereign territory of Ukraine, then it would have created certain difficulties probably for tribunals to find that it was only territory under de facto, that it's actually territory under de facto control. So my conclusion of this is that first, there is no universal definition of territory in general public international law or also in investment arbitration, and the interpretation is always text-specific, context-dependent, and requires the treaty to examine the treaty-specific wording and also the intentions of the parties. And also one interesting suggestion that unfortunately wasn't tested in practice yet, but maybe we'll see the examples. So this is the possibility of extraterritorial application of investment treaties. And this practice exists in the context of human rights in tribunals, and specifically in the case law under the European Court of Human Rights, and the famous case of Luizide versus Turkey, where the European Court of Human Rights found that the jurisdiction under Article 1 of the European Convention of Human Rights is not limited to national territory, and what matters is the effective control over territory. And I suggest that this approach can be also potentially used by investment tribunals in the future, or in some cases. But yeah, as a disclaimer, I should specify that this is for now it's an untested territory, and I don't know of investment tribunals which considered this extraterritorial approach in investment arbitration cases. But overall, apart from the extraterritorial approach to application of investment treaties, the other questions which are discussed, they already materialized in real cases that were solved, and also potential cases that are raising now in Ukraine. And some of you might have heard about the so-called Crimean cases, and where the investment arbitration discussed the application of investment treaties to the territory of Crimea, which was annexed by Russia in 2014. And in addition, since Russia's full-scale invasion of Ukraine in 2022, also many Ukrainian energy sector has, you see, all of those are Ukrainian, not all, but some of the major Ukrainian energy companies that suffered severe damages in the territories that are currently annexed by Russia, or, well, all of those territories, they are under annexation because they were proclaimed by Russian territory. And some of these companies, they publicly announced that they're considering claims under the, well, I suppose under Russian-Ukraine VAT. And so I think that in the future, we'll see more of these cases that this question of application of investment treaties to annexed territories will arise. And like in Crimean cases, a central issue in these cases is whether the BAT, the bilateral investment treaties, applies to contested annexed territories. And however, unlike Crimea here, that was annexed, like, I don't know if you remember, it was annexed as a matter of few days. The war context is different. So the control is changing very often over the territory. So I suppose that the analysis and determination of the effective control over this territory in the eastern Ukraine can be different just because of the different factual scenario. And so to conclude, I believe that we must develop an approach that would uphold both investor protection, protect also interests of the states, and most importantly, respect for international law. Thank you very much.